G'day, welcome to the Friday Workplace. Welcome again.
Thank you.
God, you had the courage to come back. That's unbelievable, isn't it?
Yeah. No, thanks for having me again.
Well, our main topic is dealing with complex contractors and contract relationships and understanding who is liable. We're going to deal with that towards the end, and we've got a case study that's built around that, both at common law and under safety law. So I thought it was a good place to sort of look at what's happening out there at the moment. We've seen so many cases where everybody ends up liable and not everyone understands quite why. But look, we'll have a look at that a little bit later. Why don't we get on to some of the early cases? Because I think Sculpture by the Sea case is a sort of fascinating case, isn't it?
Yeah.
It's a casual contractor case, which on the first instance was held that placing them on pause for a particular project was okay because they were a casual employee. But that's not what the full bench said, is it?
No. So in this case, there was a worker who installed and uninstalled art exhibitions, and they had been with the employer for 20 years. And he filed that general protections claim because of that pause in his employment. So they initially held that it was a non-binding contract because it was casual. But yeah, it was rejected.
But the history is interesting, isn't it? Because in 2004, he put in a workers' comp claim, and they changed him from a contractor relationship and permanent, a variety of different relationships, and they deliberately put him onto casual. And then shortly after that, after complaining about conduct and a number of other issues that sat around that complaint, the workers' comp complaint, then they said, look, we'll just place you on pause for this exhibition. And so what the full bench said is, well, you've got to look at the contracting behaviour as a whole, and here is a person with a continuing expectation of employment. And when you say pause for an exhibition, which is a major event, what you're really saying is goodbye. Yeah. So I put this case on for a good reason, and that is the Fair Work Commission is a restorative jurisdiction. It's beneficial in nature. It's there about looking after employees. And so they will go to the substance rather than the form of a matter on a regular basis. So look at a contract, the form, and they'll go, casual contract, you can hire and not hire as you like. But then they'll look at the history of engagement and say, but this guy had a continuing expectation of work. So I put this case on because I thought it was interesting. And I think a lot of people would have gone where the first commissioner went, and they'd be wrong. Why don't we have a look at Min and Rohana, which... Interesting case. I think when I read this case the first time, I was a little bit surprised about where it landed. But this was a car sales business, a guy who'd done some things which were pretty ordinary, but a shocking, not shocking, a very poor HR process. What did he do?
So he didn't achieve his KPIs. And so he started to manipulate them.
Yeah, he didn't only just not achieve, and then he started manipulating them.
And also got his sister on board to start manipulating them. So that was interesting. He also crashed a vehicle, high-performance vehicle, $90,000
high-performance vehicle.
And he did that for his personal use without getting that approved. So, yeah, there was a bit going on there.
And that all happened, and they eventually did a show cause. And the interesting part about this is the HR manager didn't do the things that ought to have been done, which was the warning process, the pulling up and disciplining. But the nature of the misconduct was so significant. Our producer's coughing at the moment. Just cough and get it over and done with. There you go. She can always tell when I'm bullshitting. It's terrible. And what the court said is, well, look, at the end of the day, this behaviour is terrible. It's a valid reason. And there's a shockingly flawed process. And given the size of you and the HR, it shouldn't have happened, but it's a proper basis. They had lost trust and confidence, and they were entitled to terminate. Interesting case for these reasons, because with a dedicated HR resource, when you look at the provisions under the Act around termination, it is a factor of great relevance whether you have a dedicated HR resource, and so there is a higher expectation of procedural fairness in a more sophisticated business. But the Fair Work Commission has never walked away from the issue that extraordinarily bad behaviour will cancel procedural fairness. It'll defeat it. So again, interesting case, isn't it? Okay, Manette, this is our 110th take of this one. Let's deal with Reed and Comcare, the unfortunate woman who they allege had somehow fraudulently entered and looked at her own Medicare file.
Yes.
Maybe you can break the facts up a bit more accurately than me. I'm inclined to jump over key things.
No, so she lodged a claim with Comcare for a mental injury because her role was so stressful and she was working with quite high-risk clients. And so she had her claim rejected, and that was on the basis that there was reasonable management and that her condition was caused by the misconduct investigation. And so a lot of that resulted from her being investigated by the fraud investigation team, and that was essentially accessing her own medical records.
And it was found at the end that anybody could get in to do what they said.
Yeah.
It could be anybody on
Anyone
the
on a
computer. There was no proper basis for an investigation at all.
Yeah.
But it was procedurally so flawed in the manner in which they did it. There was such a lack of care and diligence in what happened. And so, although it was an extensive process, it was a process about her management. So it was held it wasn't reasonable management action,
That's right.
that in fact the nature of the behaviour was wrong, it was flawed procedurally, and it did cause the harm. So she got up on the claim in the end.
She didn't even know what she was being investigated for.
No. Okay, a case that might be easier for me to talk about than you, I suspect, which is the Alcoa Portland Cement one. Would you prefer me to talk about it?
Yeah, go ahead.
Okay, this was an application by Alcoa to actually stop for a 3-month period or suspend industrial action. And it was run on 3 different arguments. One, that it would damage the economy. The second basis is it would help, not hinder, the actual negotiation process, and that the nature of the conduct was so drastic it needed to be intervened in. And the Commission, this is a really brilliant decision. What the Commission said is it's pretty hard for one business to say that the Australian economy turns around them. There's specific industries, and these came out of the airline industries, these cases. So there's the original Boeing case that set this going. So that's nonsense. And then they looked at actually what has occurred, and people should remember when they bring virtueless applications like this, that there will be a look at what happened. And it showed that the union had moved quite some degree, and that there was a genuine negotiation going on. And what Alcoa were trying to do was, in a predatory sense, say we're going to suspend it.
Yeah.
And that would interfere in the reasonableness of what was occurring. And so there was no suspension, and they're continuing to negotiate. This provision, or these 3 provisions, have been altered over the years to make it harder and harder to suspend industrial action, because obviously industrial action is the lever by which unions can negotiate change. And of course there is industrial action that you as an employer can take, okay? But the whole system is set around this capacity to negotiate with the threat of action. So in the end of the day, Alcoa lost. So good. I'm interested about the next case, though. I guess we see a lot of cases around flexibility at the moment. And there is a perception, certainly in employer land, that when a person asks for flexible work, that is, they can be over age 55, and that connects to the nature of what they're doing in their future. It can be because they have caring responsibilities. And that's what happened in Tracy Smith's case in Costco. She's a woman who wanted to look after a grandchild one day a week and wanted to pump up her hours in 4 days to actually achieve it. But then failed to produce any evidence of the primary link and responsibility with the grandchild. The child had parents who were able to care for them. And I guess I've only put this case on, and I've talked, and you were going to do this, but I've talked because I guess employers need to just relax a little bit. When they see a flexible work request, if there's an absence of evidence as the connection to the protected attributes that form part of that request, then yes, you still put your business case, but you're not obliged to accept it. And this went all the way through to the Fair Work Commission, who just said, but there is no evidence. There's no evidence that you have this need that sits under the flexibility provision, so we're going to deny it. And once again, I know as lawyers we're obsessed about evidence, and you and I are only having a conversation about my penchant for demanding everyone review evidence correctly. But the world of law is built on evidence first. You don't get to apply the law until the evidence is checked. And the evidence in this case is there was never evidence to support the application. So this application was destined to fail. So interesting. And a lot to learn from it, don't you think? And
she also asked for the flexible working arrangement also for her husband and his injury. Yeah, I know, and that had no success either. Odd stuff. Anyway,
very concerning development in the industrial relations landscape in New South Wales, aren't we? Where the changes to the WHS Act there will entitle unions to seek and share information from the safety regulator, and somehow somebody who's obviously sitting in a dark room without intellect thought that was a good idea. If you can imagine for a second a hostile union coming on to a contested site, alleging and in getting WorkSafe to come in or a regulator to come in and commence an investigation, and then seek as a matter of industrial leverage to prosecute themselves to get an industrial outcome, a person with a quarter of a brain would realise that is the dumbest thing I've ever heard. But New South Wales are thinking about it. Who would have thought? And the odd part about New South Wales at the moment, it is like the left brain and the right brain aren't talking. So this is a left brain dumbass thing to do for a union benefit. And the right brain's trying to say you can't bring a workers' compensation claim unless you've suffered an injury as a result of bullying and sexual harassment. And you just look at them and go,
Polar opposites.
you don't care how dumb your politics are. You're just going to do stuff which is stupid. And this is probably the dumbest thing that I've seen come through in a long time.
Do you think the bill would pass?
Look, I just hope that there's more than a quarter of a brain in the whole of Parliament that eventually says, why would we empower a union to hold a business to ransom to get an industrial outcome using safety law? Because that's what this invites. It's sort of beggars belief. Now, because I've actually jumped around this and because everyone in the room is incredibly frustrated with the fact that this is take 712 because Andrew didn't read things properly beforehand, is it time to go on to the main topic?
I think so.
Well, let's go on to the main topic then. The main topic is about looking at complex circumstances where a number of different organisations have responsibility and someone is harmed. And we saw the case of Killington Grammar not that long ago where a school had an overseas tour. There was a tour operator, a child had problems, and everybody was held liable. And everyone said that's just outrageous. They said that was outrageous because they didn't realise it's actually what the law is. Look, Justice Keogh in the Victorian Supreme Court was recently dealing with a Westgate Tunnel issue where there was a labour hire company involved. There was a joint venture who took on the labour hire employee. They're working alongside a qualified carpenter. So we've got everybody involved, okay? Yeah. And somebody had their finger amputated, all right? And at the end of the day, there was an assessment of damages that was done. And unlike safety law, in safety law, everyone has 100% liability. When you look at the common law, what it does is it says there is a pot of 100% and we will apportion liability based on your involvement and engagement, and held the employee was 10% liable for the nature of the risk they took, and then spread 90% across the field. If this was a safety case, the employee would not have had any 10% liability. Each one of those employers, because of their failure to guard against the machine, everyone failed to have policies, procedures, processes, training, everything in relation to the use of a circular saw. Unbelievable, okay? Unbelievable, because we're talking about very big players. This is a joint venture with John Holland. These are big players who fail to say and teach and train and invigilate how circular saws are used. Had this been a safety prosecution, it would have been a serious primary duties breach without a doubt. Okay, it's not, it's a common law claim. But what I want you to understand is both jurisdictions apply, okay? But in one jurisdiction, safety law, it's not 100% pot you divide up. Each person sits within that 100%, as each person has 100% risk they start with. So I thought, we've talked about that brief. It's not much that turns on it, just shows that everybody is liable because the responsibility of a site sits with the principal contractor, who then must be satisfied the person who enters the site to do work has the relevant policies, procedures, process and competency. It also says if you bring a labour hire person, they've got to be inducted into the site to know that what they're doing and who they're with, they're safe. So everybody has liability in safety law. But we thought we might put together a case study which reveals how complex that actually gets and how serious it gets based on individual knowledge. So you ready to read? Because I'm doing it. There you go.
All right, so Jim worked for Solid Concreters, a formwork company operating a Big Buildings Limited in a CBD site. He was involved in erecting vertical columns between floors on the multi-storey building. BB was a principal contractor. He engaged keeping on cranes to undertake the lifting operations, and KOC operated 3 large cranes at all time.
So big build is BB, I should say. Keeping on cranes is KOC. Just so it's me who does all this and makes it impossible for anyone to understand. I'm going to talk about loose labour shortly, and they're LL, so off you go.
All right, so KOC engaged loose labour, LL, to provide casual labour to assist with its operations. Dogmen were in short supply, and LL had several available Jim
was arranging pour to some vertical mouldings and required assistance of KOC. The assistance was arranged through BB. Over to you again.
So Jim struggled with poorly skilled dogmen from KOC, who directed the concrete bucket during pours in a dangerous manner. On 2 occasions, they knocked over formwork, and once they caused a quantity of concrete to spill next to his workers. He complained to both Terry, the director of operations at BB, and Dino, the owner of KOC.
Can I just say, Terry's my dog, and Dino runs the garage I go to. I just thought we'd add that.
Oh, goodness.
There. Yeah, no, sometimes,
You run out of names.
Fiction follows fact, doesn't it, really?
So a safety investigation. Where are we up to? A safety investigation.
Revealed the two of the dogmen used by KOC were employees of LL, and neither held a current licence.
So both Terry and Dino spoke to Mavis, the co-director at LL, with her husband, Ivan, and said it must never happen again. No further action was taken. On 16 September 2025, KOC was lifting a bucket on the 24th floor when the wind caught it, swinging the bucket wildly across the roof and pinning Jim to the wall. The crush injuries caused his immediate death. The dogman had not advised the crane operator of the wind risk, had lowered the bucket too close to the floor, and had not attached a rope to prevent swinging. The dogman was unlicensed and had little experience.
All right, there you go. Not an easy case study because there's lots of people, but the answer in this is, question 1 is, were there any safety breaches? And the answer is, if we just go through it, big build, was there safety breaches? Yes. They had to be satisfied that the crane lifting the concrete bucket, which is you pump into a bucket and lift it, was managed in an appropriate manner. They were advised that it hadn't been occurring, and all they did is say, don't do it again. So they're in strife. Okay, if we look at, who's the next character we're looking at? We're looking at...
We've got Jim. And KOC.
Well, he's dead, Jim, so he doesn't have any liabilities.
KOC.
KOC, the crane operator. KOC's director was Terry, wasn't it? Am I right about that? Yeah, I think Terry...
I'm starting to lose track.
Yeah, you're losing track, and that's the problem in this case study. So Terry was aware of the fact that unlicensed dogmen were being provided by LL. So he was told squarely it was not to happen again. And he also understood the risk, the very risk that eventuated with Jim's death. So Terry is definitely on liability. He's a breach of his personal obligation, and that is to exercise reasonable care to prevent injury to another. He's in breach of his due diligence obligation. Every state and territory in Victoria, he had knowledge, and every other state he ought to have had knowledge of the nature of the risk and failed to do anything about it. So Terry's in the strife. His business, KOC, they're definitely in trouble. But the difficulty here is for both of them. In safety law, organisational liability is based on attribution. So Terry had a knowledge, therefore KOC had a knowledge, okay? And their knowledge was there was a risk of serious injury if unlicensed dogmen did the wrong things in the manner in which they did before. And it happened again. So that's reckless endangerment. There's a level of indifference. They had to do something. They had to check that they were licensed, had the relevant experience before they allowed them on site. And for LL and for Mavis and her husband, they're squarely in the gun. Once again, they're officers, so they have officer liability, personal liability, and they have corporate liability. The difficulty for them is they've stepped up a grade because what they did was not only a breach of duty, it was so grossly negligent, given the knowledge of risk. They're facing workplace manslaughter, industrial manslaughter. So interesting set of facts. I know we're joking about how complex it is, but what I wanted to show you is there is this descending order of where liability falls. Now, at common law, they would all be liable again, okay, except LL would be extraordinarily high liability, KOC next BB a little bit. But in sentencing terms, given the nature and the size of BB in safety law, they would have an extraordinarily high liability in sentencing because safety law looks to the nature and sophistication of the duty holder. So BB are in real strife. But someone would go to jail for this.
Okay.
Whether it's under reckless endangerment or whether it's under industrial manslaughter, I think that Terry and Mavis are at real risk. So there you go. Now we go, if so, whom would be charged? We've done all that. We've done everything because we're so good today. And what I'd like to do is thank Toy, who's the producer of this, for tolerating us mucking it up so often. And can I say, it wasn't you who mucked it up, it was me. So we look forward to seeing you next week. So look, thanks for following. Give us a thumbs up and just tolerate us just for one more week. We'll see you next week. Cheers. Bye-bye.
Bye.